Ezrasons versus Rudd. We are delighted to be joined for this and the next case by our colleague from the Appellate Division, Second Department, the Honorable Carl Nodnacino. And I also wanted to mention that several of my colleagues had the pleasure of judging the final round of the Gabrielli Moot Court competition at Albany Law School a couple days ago, and we have a couple members of the winning team in the back. Welcome.
Good afternoon. May it please the court. Frank Bottini for appellants. Chief Judge Wilson, I'd request 5 minutes for rebuttal.
5, yes.
Thank you. The final two cases before the court this afternoon present an important opportunity to safeguard the New York legislature's intent to ensure access to justice for shareholders who bring derivative cases against foreign corporations doing business in New York and their officers and directors. Section 1319 of the Business Corporation Law was passed in 1961 after almost 4 years of debate and research. It reflects the legislature's careful balancing of policy considerations and takes into consideration both business interests, protection of shareholders, and the need to preserve New York's status as the leader in international commerce and dispassionately administer a known, stable, and commercially sophisticated.
Well, despite the fact that it was enacted over 64 years ago, I think we've consistently held, and courts have consistently held, that the internal affairs doctrine is going to be what decides derivative actions. So I'm just wondering why now you'd want to upend what we understand as precedent and flood the courts with these derivative actions based on something that has been in existence for a long time and has never been understood that way, the way that you want us to apply it here.
Well, we're certainly not looking to upend the law, and I believe Your Honor is referring to the Eccles decision where this court confirmed the continuing viability of the internal affairs doctrine, but the application of 1319 is not in any way inconsistent with the internal affairs doctrine. I think the misconception of respondents' position is that the internal affairs doctrine is an all-or-nothing proposition, and that's just not the case. The New York legislature chose, and in fact mandated, the application.
Well, how does it harmonize with that common law doctrine?
Why is it not inconsistent?
How does the BCL harmonize? Yes.
It's harmonized, Your Honor, because as the First Department noted, I think fairly eloquently in the Culligan decision, what the legislature mandated is if there's a statute that applies to the particular case, you apply the statute. If there's not a statute, then the normal rules under the internal affairs doctrine are applied. And in fact, our case is consistent with that harmonization principle. We allege our claims under the substantive law in the Barclays case here of England.
I understand that, but Culligan is not understood that way anymore. I think the First Department has retreated and basically said they're not following Culligan any longer. Am I wrong about that?
I think so, Your Honor. I think every court of appeal, other than the panel decisions that have considered this issue, have gone our way. And the Second Circuit in the Norland case applied 1319 and said New York law is straightforward. You read 1319, and because 626 applies in the statute, you apply 626 to a derivative claim.
So you're focused on 626.
Yes,
I
yes,
appreciate,
Your Honor.
but 1319 addresses the applicability of other provisions, it says, and it references quite a few provisions, right? So I take it under your reading of 1319 as it applies to 626, the same would be true for every other provision referenced in the statute. Is that correct?
Correct.
So choice of law provisions would be displaced for everything else in there.
Yes, everything that's in 1319 applies if the foreign corporation is doing business in New York. That's the standard. And also, Your Honor, and you're right, there are some.
That's pretty broad.
Well,
right?
that's what the legislature did. Our job is to give full effect to the statutory provisions. The legislature.
Well, of course, and that is our job as well, I think. But my question, I guess, came from wondering whether, if that was the legislature's intent to sweep that broadly, whether we would see either something more explicit in the text or some clearer signal in the legislative history.
Well, I think we have that, respectively, Your Honor. First of all, the statute says the following provisions shall apply. That's a mandate. That's not may apply. The respondent's position is 1319 is merely permissive. It just says you may apply these provisions. That's not what it says.
But if the legislative intent was to sweep aside a longstanding common law rule, you would expect more than just the word shall. We've explained that sort of title change to the law as requiring something along the lines of an explicit statement that that is in fact what the legislature is attempting to do. There's nothing like that in 626, is there?
Well, there's 1319 contains the shall language, Your Honor. 626 is the provision governing the maintenance of derivative actions in New York.
All right, so what about 1319? What do you derive out of 1319 that evinces an intent to supplant the internal affairs doctrine?
Well, because when you look at the provisions of the BCL, they're listed in 1319. There are substantive provisions there. They wouldn't have listed substantive provisions if they didn't intend to partially set back the internal affairs
But
doctrine.
it could have been as against the backdrop of the common law, couldn't it? I mean, isn't the question before us whether or not the backdrop of the internal affairs doctrine remains in play, and this is against that context, or whether it actually displaces all of that?
I think all it is, Your Honor, is to recognize that New York, given its preeminent position in international commerce, chose to adopt a modified version of the internal affairs doctrine. Because of the importance of New York law, and because actually business interests want New York law applied. We have in the next case contracts containing New York choice of law and form provisions. And because of the importance of that, they said certain provisions of our law are going to apply. Dean Stevens, who wrote a very seminal article about the passage of 1319, said, it would completely undermine the intent of the legislature in mandating the application of these provisions if a company doing business in New York could go across the state lines, incorporate somewhere else, and get around New York law.
So let me ask you this then, Counselor. What's the state of awareness in the business community at large? Do you think the foreign managers of foreign corporations are operating under the understanding that New York's BCL controls who can bring a derivative action versus their own local law? In other words, do they put any credence in our internal affairs doctrine?
Well, I think they're aware of the statute. The statute's been on the books since 1961, and again, it was...
So then you would answer yes. Foreign managers assume
Yes.
that the BCL is what controls in terms of who can bring a derivative action, even if their own statutes say you can't bring a derivative action.
Right, and they understand if they do business in New York, they're going to be subject to certain provisions, not all. And again, the substantive law governing liability of the directors will still be governed by the foreign law, and that's why our position is perfectly consistent.
So how do you define what a shareholder is?
What a shareholder is?
Yeah, how do you define that term?
It's very simple. You read 1319, which is plain on its text, and it says 626 applies. Then you go to 626, and 626 says a beneficial shareholder can bring a derivative claim. So therefore, 626 applies, just like this court in Davis held that it applied. The foreign rules are procedural. And in Davis, this court held that those procedural gatekeeping rules of the foreign corporations locale will not apply. And so in Davis, 626 was applied. In the Norland case, the Second Circuit said, all you have to do is look at 1319 because 626 is listed there. 626 applies. The Second Circuit applied it. Culligan applied 626.
Counsel, 626 in another section has a demand requirement, 626C, right? So if we're dealing with a foreign corporation and their home jurisdiction also has a demand requirement, which one needs to be followed?
626. as long as it's doing business in New York. That's what the legislature said.
So if it is not doing business in New York, what happens?
If it's not doing business in New York, then the shareholder cannot file suit here. Very straightforward. The other decisions that have looked at this issue, 1319 was not raised. That's one of the reasons I think, Your Honor, when you see some of these decisions in the lower courts and they go the other way, it's because the shareholders never raised 1319 for
Well,
whatever
shouldn't
reason.
that tell us something?
No, it's just that the plaintiffs don't always raise all the applicable provisions available to them. A lot of the times what you were dealing with is Delaware corps, and everybody's focused on Delaware law, and everybody looks at Delaware law. Well, New York has its own laws, and they're not always cited. Culligan looked at 1319 and said, wow, you read it, it's very simple, it's very straightforward. These other cases that are cited by the other side didn't involve 1319. The text of 1319 must be given effect. The legislature chose that. Also, if you think about it, their position, if you credit it, you'll have to throw out all kinds of provisions under the BCL. You'd have to throw out 1317, because 1317 says if you're a foreign corporation doing business in New York, 719 and 720 of the BCL apply. You're just going to throw that out after the legislature passed that important statute? And what do you do about 1320? Take a look at section 1320. It's very important of the BCL. In 1320 is an exemption statute. And 1320 says a foreign corporation doing business in New York doesn't have to comply with some of the other provisions that we just said are applicable if one of two things apply. Either its shares are traded on a national stock exchange, or it derives less than half of its income and revenues from business in New York. Here's what's so incredible. It exempts certain provisions of 1319, but not 13A2. 626 was so important to the New York legislature to apply to protect shareholders that they said that's going to apply even if the foreign corporation stock is publicly traded, and even if it doesn't derive more than half of its revenues from New York. You can't reconcile all those provisions of the BCL with the respondent's interpretation, but you can with our interpretation. Because again, the New York legislature, because of the importance of all these foreign companies that want to come in and take advantage of New York's business, list their shares here, raise their capital here, billions of dollars in capital that they raised in these two cases before the court. We have a $63 billion acquisition in the Bear case, and Barclays was fined $18 billion in New York for activities that they undertook in New York. And
The
so-
Joint Legislative Committee to study the revision of corporation laws, right? You know who they are. They studied these laws and gave their opinions as they were switching over, said that Section 1319 was merely a list of business corporation provisions that apply to foreign corporations, and only to the extent provided therein. It doesn't seem that there's any creation of any substantive rights by the people who were tasked to study this.
It's interesting, when you look at the joint report, both the state and city bar of New York opposed 1319. They said it's an improper attempt to regulate the internal affairs of foreign corporations beyond what other states have chosen to do. The New York legislature rejected that opposition. They did choose to regulate the internal affairs of foreign corporations, not across the board, but just in limited circumstances, and 626 is one of them.
Let me ask you this regarding the debate over 1319. What was the dialogue specifically as it relates to 626A in that debate? Was there a loud hue and cry from the community that 626A was unfairly impinging on the internal affairs doctrine?
Well, we don't have all the exact comments.
'Cause I couldn't
that were
find
made, Your
anything.
Honor, but-
I couldn't find anything about that. It sounded to me like whatever they were debating, no one was seriously concerned that 626A was going to damage the internal affairs doctrine. But we now find out from you that it actually completely sets aside the internal affairs doctrine.
No. Again, it doesn't completely set it aside. It just reflects the New York legislature's policy decision, which we must respect, to have certain aspects of New York law apply, and 626 is one of them. As to the substantive law of liability of directors, that's still governed by the foreign law. So that's consistent with Eccles, and it's consistent with the fact that New York chose to adopt a modified version of the internal affairs doctrine. It's not a casting aside of the doctrine, Your Honor. I reserve my other time for rebuttal. Thank you.
Thank you.
Good afternoon. Lara Flath for the respondents. May it please the court. I think the questions that have been raised by this panel are precisely correct and precisely why plaintiff's argument is completely wrong with respect to the internal affairs doctrine.
Can I ask you to address the German-American copy case? Because it seems to me that maybe Judge Cardozo's a reading of the law there suggests that perhaps we could read 1319 as the plaintiffs suggest.
Of course, Your Honor. That case specifically deals with Section 1317, which is obviously a very important distinction because, in fact, Section 1317 does reflect choice of law. It talks about direct actions against a corporation by foreign corporations and with respect to domestic corporations, which is different
So
than...
you're saying there's a distinction in the text of the two statutes that leads to a different result?
Indeed.
And what exactly, go ahead.
No, please, I'm sorry, Your Honor.
I was just going to ask you what that is.
The difference certainly is the language of the statutes in which Section 1317 does reflect that the same for domestic corporations shall apply to the same extent, right? An action against a foreign corporation shall be against the same extent as a domestic corporation. 1319A2 has no such language and in fact reflects except as provided thereon, precisely as was recognized before by Judge Singas.
So what is 626 if it's not a legislative statement regarding standing in derivative actions?
626 certainly allows for derivative suits to be brought in certain circumstances, but it is not
What are those circumstances?
if, in fact, there is standing, all of those sorts of pieces.
So it does not confer standing in and of itself.
Correct.
Why not?
Because one should look, when you are dealing with a derivative suit brought on behalf of the corporation, what fundamental law should apply. That is still the internal affairs doctrine and how it applies.
So is 626 brand new as of 1961?
Your Honor, I don't know the specific
Didn't it
date in which
didn't-
626
didn't-
was in, but we
Yeah,
focus on the
didn't-
BCL and certainly in 1319 here with the legislative history.
Wasn't it actually in the same words in Hank Verba, Business Corporation Law 61, that existed for half a century at least before that?
Yes, I mean,
And
this-
aren't there cases under that in which people have standing, had standing?
they do. Certainly, reading 626 should not, in fact, suggest that a derivative suit on behalf of a foreign corporation could never be brought in New York. It is simply the application, and to assess that question, you should look to the internal affairs doctrine on the substantive law. and
Was
standing
that
as
ever a
corporate.
question before 626 was enacted? I'm still struggling to understand what the purpose of 626 is if it's not conferring standing. What else? I'm struggling to understand what else it could be doing.
It's certainly when the BCL is enacted and Section 13 in particular comes together to sort of explain what provisions do and do not apply to foreign corporations and enumerate that. 626 can, in certain instances, apply to a foreign corporation if, in fact, the foreign corporation is doing business. Yes, certainly, New York law allows for derivative suits in particular instances to be brought. 626 allows that to happen, but it is not.
Isn't 626 merely a floor, which says that if you don't have these minimal requirements, then you can't bring a derivative action? That's the way I read it.
I would agree. And those two, 1319 and 626 read together, are the statutory predicates for subject matter jurisdiction over shareholder derivative suits brought on behalf of a foreign corporation in certain instances. But it is not automatically.
Where's the in certain instances?
In certain instances, a shareholder suit may be brought. It is not always and automatic.
I'm not really sure what you mean by subject matter jurisdiction, because the Supreme Court is a court of unlimited jurisdiction, has general jurisdiction. So in that sense, Why is your use of subject matter jurisdiction different from a cause of action?
Certainly, Your Honor. At the time of the BCL being enacted, numerous courts, in fact, were rejecting jurisdiction over foreign derivative suits all to begin with, because they read the Internal Affairs Doctrine as being so strong that, in fact, New York courts could never have jurisdiction. Article 13 codifies which provisions may apply in certain instances and narrows to those corporations doing business in New York. So that it does pull that all together, that in the legislative history, in fact, supports a reading that can be harmonized with still continuing to apply the Internal Affairs Doctrine.
But with respect to 1319 and 626, the limitation is doing business in this state. It doesn't say anything in a foreign corporation, so long as they had standing in the foreign jurisdiction to have initiated the lawsuit. It doesn't say anything like that.
It doesn't, Your Honor, but certainly 1319 on its face should not be read as a choice of law provision. Choice of law provisions are very rare under the
So
restatement.
what do you think
conflicts.
it is? I mean, does it confer any authority at all? Create any rights or obligations? It seems like you're suggesting it's sort of a Cliff's Notes listing. I don't mean that to be, I mean, tell me, how do you see it?
Your Honor, we would say that it does in fact clarify and enumerate all of the provisions.
Well, by clarify, do you mean change in any respect, or simply, what I mean by Cliff's Notes is simply that I take it you're suggesting it's just listing in one place a bunch of provisions. Is that right?
That is, Your Honor.
And that's kind of unusual. I mean, I don't think legislatures often pass a statute simply to do that. Usually they are enacting a law that has some consequence for parties, for anyone subject to the terms of the statute.
It may be unusual, Your Honor, but I think it does serve that purpose. As we've talked about and the panel has discussed, there was a lengthy process by which the BCL was enacted in 1963, several years of discussion over that. And in fact, 1319 does list out those particular provisions, providing clarity so there was no more
What do you do
confusion.
about the legislative history, the State and the City Bar Association reports, which treated very differently?
So in that instance, Your Honor, first, the submission of the Bar Commission, the report, is not part of the legislative history, and in fact, was commented.
Yeah, but we do often look to documents like that as shedding some light.
Certainly. It was commenting on a draft, an earlier draft, and in fact, the opposition was later withdrawn. That's in the
But
compendium.
wasn't the earlier draft identical in language to the final version enacted?
Well, it is hard for us to tell because, in fact, it doesn't specify that the objection was to 1319A2. It talks about those pieces. It's certainly withdrawn, so to suggest that because that objection was raised and never taken back, that this must mean there was an objection to the Internal Affairs Doctrine being overturned.
But counsel, it simply says a holder of shares. Very basic, right? Why would you need anything more? And why wouldn't the state have an interest in these derivative suits for shareholders to protect their interest here?
Because we are talking about a shareholder derivative suit, in which case the plaintiff seeks to step into the shoes of a foreign-based corporation. And the Internal Affairs Doctrine dictates, just as recently as this last year and consistently in numerous of these cases, that in fact it should be respected. And that is both with respect to the expectations of shareholders who choose to invest in a foreign corporation with all of the principles for policy, for expectation of interests, for knowing what restrictions apply to them, in which case they can or cannot bring these types of
But they
suits.
certainly could have made the choice to invest in a foreign corporation that's doing business in New York, right? It's doing business in New York.
It is.
New York law applies according to this, not only procedurally, but at least for standing purposes.
But the provisions there, Your Honor, in 1319 and 626 still say nothing expressly about standing. And standing is a substantive requirement, particularly in the context of
So
a
is
derivative
that,
suit.
it needed to say that this is a provision that recognizes standing?
There should be something that would expressly identify it as a choice of law provision to then displace the internal affairs doctrine. That truly is what is happening. If we were to adopt.
Again, if it's not a choice of law provision, it's doing what work?
It provides the statutory predicate to jurisdiction, which at the time of the enactment of the BCL was in fact an open question as to whether or not New York courts in any circumstances would exercise jurisdiction over a shareholder derivative suit brought on behalf of a foreign corporation.
That was
Yeah,
a question when, I'm sorry.
No,
Go ahead, Jay.
just to follow up on this. So when you say a statutory predicate to jurisdiction, are you saying that this establishes jurisdiction, that this is a jurisdiction granting provision?
Yes.
Okay, I'm trying to figure out what the predicate to jurisdiction, that phrase, what you meant by
Sure.
that.
Yes, because it does then impose the additional restriction on corporations doing business in New York, and in fact narrows the jurisdiction that can be exercised. If a foreign corporation was not doing business in New York, there would be no jurisdiction over this type of suit. We focus certainly on the plaintiff standing aspect, but that also then provides a limitation from the perspective of the company itself. So doing business in New York is simply not enough to then say a particular plaintiff automatically is able to bring suit standing in the shoes of the foreign corporation itself.
I want to go back to the last thing you said about 1319-626, because it's pretty, impactful. Are you saying that at the time of enactment, it was an open question in New York whether a shareholder could bring a derivative action against a foreign corporation in the New York courts? That was unanswered.
That, yes, Your Honor. And
Surely there had to be foreign derivative actions at least commenced in New York prior to the enactment of these provisions.
And courts, in fact, were rejecting those under the internal affairs doctrine because New York did not have jurisdiction. That's discussed in the Lewis versus Dicker case at the First Department from some time ago.
And not because not because of what you said before, not because they weren't doing business in New York or some other grounds for jurisdiction. You're saying because under the internal affairs doctrine, because these were entities governed by foreign jurisdictions, there was no home for them for their disputes in the New York courts.
Certain courts were interpreting that to say there is no subject matter jurisdiction here.
Did you happen to come across a appellate division case called Hirshhorn v. Hirshhorn from 1952?
I don't know that that is cited.
I didn't see it in the papers. You'll have to take on faith that I'm describing it roughly correctly. But it was a 3-2 split in which three justices said, it was the question in the case was whether New York or Canadian law governed concerning a Canadian corporation. Canada had a registration requirement just like the ones here. New York didn't. And three justices sent it back to the Supreme Court to determine whether the registration requirement was real or not. Two justices dissented on the ground that General Corporation Law 61, which is the precursor to BCL 626, applied. Two of them held that it applies, and you would disregard the foreign registration requirement. Any thoughts about that? Well, let me ask it this way. Is it possible that the drafters of this, Dean Stevens, who wrote Stevens on Corporations, and was involved very heavily in all of this, and others, would have known about this case, and then that should guide our interpretation somewhat about what was happening with 1319 and 626?
Your Honor, very, very challenging to answer that, but certainly since these provisions have been enacted, I think it is important to go back and to correct something that plaintiffs sort of suggested in opening, which is that any court who has looked at this has found that 1319 should be respected. In fact, Culligan is the rarity and has not been interpreted in the same way.
Culligan is much later. I guess what I'm wondering about is sort of this, is if the idea of the internal affairs doctrine that you're very heavily relying on has really taken form after 1961, and that if you were looking for things about the internal affairs doctrine before 1961, you'd maybe find kind of a mishmash of things, and it was not formed this way, so that you might actually require a lot less specificity than you see in the revision from 1961, which was done pretty comprehensively. I also don't know if you've gone, but I and my law clerk spent a great deal of time. There's about 150 research reports that are only in the state archives here that have some bearing on some of these questions. So just whether it's possible that the doctrine you're referring to really evolved after this legislation was enacted.
The internal affairs doctrine has been a principle that has been used and respected for a very long time, including prior to the BCL.
Yes.
In terms of the proliferation of shareholder derivative suits and the application and an increasing global world and business in operation, certainly I think that you do see changes for those reasons. And to that point, the Companies Act, which we are talking about, right, enacted in 2006, recognizing certain of these requirements with the guise that the internal affairs doctrine certainly should apply.
And it's possible the United States or New York in 1961 thought it had a bit more power in regulating international markets than it does today.
Certainly could be the case, Your Honor. There's many things to talk about, but when we look at the interpretation of how these provisions have worked for the last 60 years, consistently it has been that the internal affairs doctrine will dictate you should look to the substantive law of the place of incorporation.
And so how would you address counsel's argument about Section 1320?
Your Honor, certainly 1320 is really not mentioned at all in their briefs, and so I was looking to figure out where that comes up. And with the legislative history, it is a bit more, I think, of the particular differences, but it is trying to sort of say it, and is, I think, an example of what 1319 could have done, just like 1317. Had, in fact, the legislator decided they wanted to do something expressly and explicitly, they could have done so, and they did not in the instance of 1319A2.
Yeah, but 1320 seems to exempt portions of 1319, and it's kind of hard to understand why that would happen if 1319 sort of did nothing other than collect things.
So with respect to what 1320 deals with, I do think it is particular aspects that it is drawing that distinction, and then to sort of imply that 1319 means something because of what the legislature did not do takes that a step too far. The 1320 point is sort of just beyond on those pieces, and there's nothing sort of discussing that difference that would say that means that the internal affairs doctrine should not apply for suits brought on behalf of a foreign corporation. To turn sort of just very, very briefly, again, about, counsel mentioned and discussed extensively the Norland case. That's from 1984 and was discussed in the Eccles case just this last year as not really standing for that particular provision. And when, in fact, the internal affairs doctrine is applied here, it is clear that standing is a substantive requirement under English law and should be respected for a host of policy reasons, including to protect the interest of shareholders as well as the directors, the officers, and to avoid forum shopping, too, in order to ensure that there is not a floodgate that is open, that any plaintiff who does not have standing under the law of here, England or other jurisdictions, can just bring suit.
Let me ask you, if the substantive requirement of, doesn't have to be the English company law, some other foreign jurisdiction substantive requirement provides standing to a larger group of people than the persons named in 626, would the New York courts have to respect that determination made in a foreign jurisdiction?
I think yes. The answer would be yes. In fact, you should look to who is able to bring suit under the substantive requirements. And so in those instances,
So
yes, it could be.
Then you've just admitted that 626A would actually supplant the internal affairs doctrine.
No, I think it still, it looks to, again, it still dictates that the question of standing of who is able to do that would be also then permitted under law. That is, I think, the twist, Your Honor, is that 626A is not the deciding vote. It is the internal affairs doctrine, meaning the substantive requirements of that place of
You're
incorporation.
not saying the legislature couldn't have displaced the foreign registration requirements for suit, are you? You're just saying it didn't.
It did, correct, Your Honor.
It could, though. If the legislature had been clear, they could have done that.
Correct. Unless there are no further questions, I feel in time.
Thank you.
Very briefly, we didn't get to discuss the substantive versus procedural issue. I'd like to briefly touch on that. Regardless of how this court comes out
Is
on,
that an issue in this case? Is that
Yes.
preserved here, substantive versus procedural?
yes, because that's what the lower court decided on. It decided that the standing requirement was substantive and therefore had to be applied under the law of England, the English Companies Act. So here, regardless of the interpretation of 1319, this court's holding in Davis requires reversal of the First Department's
Well, I
panel.
think it's a question of what argument you made that's preserved regarding that substantive versus procedural.
Well, it's inherent in 1319 because 1319 is a choice of law provision. We argued that it displaces.
No. Did you preserve an argument that the foreign law that you might not satisfy, your client might not satisfy, is merely procedural, not substantive?
We did.
I
and
think that's what Judge Contar was asking. I may have misunderstood him, but I thought that was the
Can
question.
you point us to where you,
Yeah,
over here,
I
can you
don't
point
see your
us to where
argument.
you preserved that?
we submitted the statute. I'm looking at record page 961. We made arguments in the First Department. We cited the Davis case where there was a lengthy discussion of that issue by mere.
In Nisi Pruis, not at the appellate level.
We cited Davis for the proposition that Davis's holding required, the whole holding of Davis is on procedural versus substantive. By citing the decision alone, we preserve the issue, Your Honor, in the trial court. And again, the section here in the English Companies Act, which is in the record at page 961, is identical in substance to the Cayman Island procedural rule that this court in Davis said was procedural and therefore didn't govern in a derivative action filed in New York. Instead, New York's gatekeeping rules, specifically 626, apply. So on that basis alone, reversal is required. Section 260 of the English Companies Act says, this chapter applies to proceedings in England and Wales or Northern Ireland by a member of the company. That's a procedural rule, just like the rule that this court said was procedural in Davis, because it only governed actions filed in Bermuda, in the Cayman Islands. And so this provision of the English Companies Act only would apply if my clients had filed their case in one of those jurisdictions, England, Wales, or Northern Ireland, and it didn't. And moreover, as this court held in Davis, there's no indication in the English Companies Act that this provision was meant to apply to cases filed outside of England or Wales or Northern Ireland. So on that ground alone, reversal is required regardless of the interpretation of 1319. And finally, again, we don't think that our interpretation is in any way inconsistent with the Internal Affairs Doctrine. It is consistent. We plead the substantive law of England.
Are there any jurisdictions that follow your interpretation?
Yes, the Second Circuit's decision in Norland followed it. Culligan followed it. And again, Your Honor, many of these cases didn't look at 1319, so that's the real problem, and Culligan mentioned that. If the parties don't bring 1319 up, the court's not going to address it or decide it. So most of the decisions haven't involved 1319, and they've been decided purely on the procedural versus substantive grounds.
So if we agreed with your position, wouldn't that make New York an extreme outlier?
I wouldn't say an extreme outlier, but it is an outlier, Your Honor. New York applied a modified version of the Internal Affairs Doctrine when it passed the BCL in 1961. It didn't sign on to an unadulterated version. California also adopted a modified version of the Internal Affairs Doctrine. California, like New York, has, as part of its corporation code, numerous provisions of the Corp Code that will apply to companies doing business in California. New York and California are the two most powerful states in the United States when it comes to business. They demanded that certain parts of their law apply to these companies that are coming into this great state and taking advantage of doing business here, raising billions of dollars, having their stock listed on the stock exchange, and they said certain provisions were going to apply. So that's what they did. It's in the legislature, in their infinite wisdom, decided this is what we want to do. It's not our job to second guess what the legislature did. It's our job to faithfully apply the statutes that have been passed. And they
But what about what your shareholder did? Your shareholder decided to invest in this company, and with that carries all that occurred in that home jurisdiction, right? Including the statute, including what the articles of incorporation might say. So isn't it unreasonable for them to expect to come here and just cast that all aside?
Well, no, Your Honor, they're definitely not casting it aside. Again, the rule, the New York legislature gave my client, and by the way, my client is a New York resident, and my client got the right to file a derivative case here as long as Barclays was doing business in New York. And boy, is Barclays doing business. I mean, have you been to the Barclays Center in New York? Have you seen their high-rise tower in New York? They say that their second home market is New York. This is not some minor doing business in New York. So my client did what the New York legislature said he is entitled to do. He's not casting aside anything, and the rules that they're trying to assert are procedural rules that this court has said in Davis do not apply when a derivative case is filed in New York. So it's perfectly consistent with the company's rules and the New York statute, Your Honor, not in contravention of it.
Okay. Because
Thank you. Thank you.
I'm sorry, go ahead.
That's all right. Well, that's why I asked you before, how do you define a shareholder, right? Because if you start off as investing in that company and you understand what the nature of that investment means, it's all encompassing, isn't it? Isn't it all part and parcel of what the statute says, what the articles say, what you can expect to have as a right? I mean, you have shareholders that have limited powers, right? Certain voting rights, various types of things. And then when you come here, how does a trial court grapple with that, right? They have to make some determination as to whether or not this person has a right to bring the case, right?
Yes, Your Honor, I agree. And the only issue here was our client as a beneficial owner allowed to bring the case. And 626 is very clear. Beneficial owners have the right to bring the claims. And 626...
So yes, you get to file the case, and then you're subject to the substantive law of the jurisdiction in which you're incorporated. And under that substantive law, if you're not allowed to proceed with the action, it gets dismissed.
But
Why is that not a good harmonization of the BCL and the Internal Affairs Doctrine?
because as reflected in the statute that I mentioned earlier, the section of the English Companies Act where the member requirement applies is part of their procedural rules regarding filing cases in England and Wales and Northern Ireland. It's not part of the substantive law. That's the reason, Your
Well,
Honor.
let's say we found differently, that we disagreed with you, if we could even reach it. If we disagreed with you, why isn't what I've suggested to you the way you would harmonize the BCL and the application of substantive law from the country where the foreign corporation is incorporated?
Well, again, because 626, this court has held in Davis, is part of New York's gatekeeping rules. It's not a substantive provision, as this court has interpreted it. And so we apply our own... 626. And 626 says beneficial owners can bring claims. 626 is all about standing and what it takes to bring a derivative claim in New York. And remember, the BCL was part of a major push to modernize New York's business corporation law. And there are no record holders anymore. Seed & Company is the only record holder. And in order to facilitate electronic trading of shares, everything in America moved to beneficial owners. Otherwise, you couldn't clear the trades quick
And what
enough.
if that's all correct, what is your response to Eccles' concern about companies being subject to different requirements in different jurisdictions? Because I think even you would concede that a beneficial owner could not bring this derivative action in the home jurisdiction, but they can here. And now the company is dealing with different sets of rules depending on what forum they're in. Is that just immaterial to the question?
It's not immaterial, but I think in Eccles, the concern was different substantive liability rulings, and that's not at issue here. Here, it's the gatekeeping rules, and there's no inconsistency in gatekeeping
Who's
rules.
suing you isn't a substantive question. Who can bring an action against you and who can't is just a gatekeeping function?
Whether you're a beneficial owner or record holder is not a substantive issue, Your Honor. You own the shares.
That wasn't my question, though. My question was who can sue? Who actually has a right of action against you? And you're saying in this jurisdiction, it's shareholders and whatever the three categories are in 66. And in the home jurisdiction of this company, it would not include beneficial ownership. It just doesn't. That seems obvious.
No, it's not a substantive issue, Your Honor. It's part of 66, again, and Davis said that this is a procedural issue. Whether you're a record holder or beneficial owner is a procedural issue. Just like what you need to allege, demand futilities, other issues, these are gatekeeping issues at the beginning of the case. They're not issues dealing with the liability of the directors, and that was the concern in Eccles, and therefore, Your Honor, I respectfully submit, we don't have in this case the concern for inconsistent rulings that Eccles mentioned. We just have procedural rules, and regardless of how you interpret 1319, we need reversal here because even under Davis, procedural substantive, this was a procedural rule.
Thank you.
Thank you.